direction. It passed comfortably in the House with all Democrats voting for it and 10 Republicans voting for it. Congress had originally asked for the invocation of the 25th Amendment by the vice president. This would have allowed the vice president to gather with the president's cabinet, take a vote, and then remove the president by operation of that vote. The vice president formally determined that he was not going to do that, gave his reasons to the Speaker of the House. And so following the vice president's refusal to invoke the 25th Amendment, the House proceeded with its article of impeachment, which was passed yesterday. So a number of questions and problems arise from the impeachment. We don't know exactly when it is going to begin in the Senate. The trial is going to begin in the Senate, but it looks like the determination has been made by the current majority, led by Senator McConnell, that the impeachment trial will not take place until after President-elect Biden is sworn into office next week. So it now looks as though, and I suppose anything could change, but I suppose at this point it is fair to say that it looks like the President Trump, will not be tried on the article of impeachment until after he has left office. All right. Now, one of the things I think that was curious yesterday was we didn't see a real aggressive defense of the president's conduct. There were some defensive arguments made, but those arguments tended to focus on the process rather than a specific defense of the president's conduct. Now note, that is very different than what we saw in the first Trump impeachment, which was just a little over a year ago, right? Where a number of members of the House made arguments in defense specifically of the president's phone call with the Ukrainian president. That was not true, largely speaking, yesterday. Most of the defenses that we heard were procedural or process-based defenses. And I think that we will continue to see that in the Senate. So things like, this is a rush to judgment. We've moved too fast on this. We haven't held any hearings. We haven't heard from any witnesses. There has been no learned testimony from constitutional scholars, right? So I think you're going to see a variation on those kinds of process arguments as we move into the Senate trial. Another question is this: can the president even be tried in the Senate once he has left office? In other words, can you convict a person in an impeachment trial who no longer holds the office? I mean, after all, one of the remedies of impeachment is that you would remove the official from office. Well, President Trump can't be removed from office after President Biden has been sworn in. So this will be a live issue. Now, there's a short answer to this, and then there's a more complicated answer to it. The short answer is yes, there is precedent for holding an impeachment and an impeachment trial for an official who is a former official, that is, who no longer holds the office for which they have been impeached. There is actually an American precedent on this. You'll probably be hearing the name of William Belknap over the course of the next few days. Belknap was Ulysses S. Grant's Secretary of War and was accused of essentially graft. He was essentially accused of enriching himself while he was serving in the cabinet. This was back in the late 1800s. The Grant administration was widely regarded as a corrupt administration. I mean, the Grant administration is known as one of the most corrupt administrations in American history. So to some, this was just part of a piece of the conduct of the Grant administration. But nevertheless, Belknap had engaged in a very lavish lifestyle, which many people thought was odd given his $8,000 salary. And so he eventually was, after an investigation, he was impeached by the House. Right before he was impeached, he offered his resignation to President Grant, and President Grant immediately accepted the resignation. So formally, Belknap had resigned from office before the impeachment occurred. The House nevertheless continued with the impeachment, and the Senate continued with the impeachment trial. Now, Belknap was acquitted. That, I think, should be noted. He was acquitted. And an overwhelming number of the senators who voted to acquit him did so on the ground that the Senate did not have jurisdiction because Belknap was no longer in office. So that's an important historical point, I think, to make, that there were a substantial number of senators who thought the Senate lacked jurisdiction. The problem with that is a majority of the Senate thought it did have jurisdiction. So arguably here, the more important precedent arising from the Belknap case is that the Senate decided that it did have jurisdiction over a former officer. However, complicating that was this notion that Belknap had resigned solely to avoid impeachment, right? That would not be the case here, right? It's not like Donald Trump is resigning from office just to avoid impeachment. He is leaving office by operation of the Constitution. There's nothing he can do about it, right? So you might see some arguments that the Belknap case is not really a precedent that is directly on point here with regard to the jurisdictional issue. But nevertheless, I think the Senate is going to receive that as a live problem. But if you look back at the history of English impeachments, there are examples of former officials being impeached, the most famous one being Warren Hastings, whose impeachment trial, by the way, lasted for 7 years. But he was impeached after he had left office as the Governor General of Bengal. All right, so a final issue that you might hear with regard to the Trump impeachment is free speech. And you're going to be hearing the case Brandenburg versus Ohio, if you haven't already heard about Brandenburg and the incitement doctrine under free speech law. You'll be hearing about this, but I don't know how relevant that it's going to be. For purposes of this proceeding, the president is not being criminally prosecuted. No one is trying to sue him based on his speech, even if his speech is constitutionally protected, and that is questionable, right? Brandenburg says that if the speech is likely to produce imminent lawless action, it is not constitutionally protected, right? So I think there is an argument here that Brandenburg doesn't cover the president's speech. But even if it did, and there is a good argument that it might, even if it did, we're not talking about criminal prosecution or a civil suit here. We're talking about impeachment, right? So the mere fact of a person's speech doesn't protect them necessarily from the consequences of that speech if they are a government official. And it certainly wouldn't, I think the weight of authority would say this, that it wouldn't immunize the president from impeachment. The idea here, the theory of the article of impeachment, is that the president's speech reflects an abuse of office and his failure to preserve, protect, and defend the Constitution and take care that the laws are faithfully executed, which is the kind of the underlying theory of the impeachable offense here. So, so the real problem, and I think you'll hear some members of Congress and the Senate talking about this, the real problem might not even be the president's speech to the rally. It might be his failure to do anything once the insurrection had begun at the Capitol. So you'll hear all of these arguments, but I think those are going to be the competing arguments in the Senate. All right. So the next thing that I want to mention briefly, and I know that Professor Exum will cover this ground as well, is the criminal charges. We're already seeing some criminal charges being filed, quite a few of them. We know that these investigations are continuing both by the Capitol Police, the FBI, the Department of Justice. So I would say expect more criminal charges to come and expect more serious criminal charges to come. One of the criticisms that I'm hearing from a lot of folks right now is, well, these charges seem to be very low-level charges. That's true. But remember, most of these right now, we're just talking about criminal complaints. These are not indictments, right? Once the cases start going before grand juries, the prosecutors are going to start asking the grand juries to return indictments on more serious offenses. So stay tuned, because I think we are going to see quite a few more very serious charges being brought. That's going to include things like conspiracy, homicide charges, potentially, the federal equivalent of felony murder charges, sedition, right? Seditious conspiracy. And then for those of you who remember your criminal law, you will remember that in federal court, there is something known as the Pinkerton Doctrine, which says that if you're involved in a conspiracy, you are guilty not just of being a conspirator, you are guilty of any substantive crime committed by any other member of the conspiracy, as long as that crime is either in furtherance of the conspiratorial objective or is reasonably foreseeable. And I think you're going to hear a lot of people saying that the death of a police officer here was reasonably foreseeable. So, well, that depends upon what the underlying conspiracy is. But once a conspiracy can be established in federal court, then the Pinkerton doctrine kicks in. So something to keep in mind, I think. We'll also have to see whether the president is subject to criminal charges. I think that's a very complicated constitutional question, even after he leaves office, because of the potential speech implications here. And then we're also going to see whether some members of Congress are subjected to criminal prosecution. I'm already seeing reports and hearing stories about potential complicity by members of Congress. Obviously, we're going to need a lot more facts on that. Hard to tell at this point, but those stories, those reports are being floated right now. So we'll see if that's the case. And then, of course, even if you can't criminally prosecute a member of Congress, there is still the possibility of expulsion from the relevant chamber. All right. So we'll see what happens. But Professor Exum will talk a little bit more about the criminal side of this. Pardons. There's talk about a self-pardon by the president. That's complicated, that's controversial. There is a lot of authority against this, although there are some that have made the argument that he could potentially do it. One of the arguments is the pardon clause speaks in terms of granting reprieves and pardons. And so some scholars have argued you can't grant something to yourself, right? To grant something means to give it to someone else, right? Another argument is kind of a structural constitutional argument, which is it would defeat the Constitution's purpose of making the president liable for a prosecution after he leaves office, right? If he could just pardon himself. The Office of Legal Counsel at the Department of Justice issued an opinion in 1974 saying that the president cannot pardon himself, in part because the OLC had also concluded that a sitting president cannot be indicted. And so OLC's position was you can't have both, right? If a sitting president can't be subject to indictment and prosecution, then surely he can't pardon himself, right? Because then that would be a sort of a windfall for the president, all right? The other problem is the potential pardon of those who engaged in the violence at the Capitol, right? Now, I'm not sure how likely that is, but remember that remains a possibility as long as President Trump remains in office, right? So keep an eye on the potential pardon situation with regard to the events of January 6th. Finally, just let me mention very briefly the 14th Amendment, Section 3. This is an obscure provision of the Constitution, okay? We haven't talked about it much. There's not much authority on it, but Section 3 of the 14th Amendment, passed after the Civil War, of course, says that anyone who engaged in rebellion or insurrection against the United States, or who gave aid and comfort to anyone engaged in rebellion or insurrection, cannot serve in federal office, right? They are disqualified. No one knows exactly how this operates, right? There's very little authority on this. It has been done. It was done in 1919 with regard to a socialist who wanted to serve in the House. It was done in the late 1800s. One of the relevant precedents is a case called Griffin's case, in which Chief Justice Chase presided. So one of the arguments about Section 3 is that it's not self-executing. And so we don't just declare that people are ineligible under Section 3. Congress would actually have to pass legislation, the argument goes, to make someone ineligible. But that remains a possibility. Congress theoretically could pass a law declaring that a particular person is ineligible to serve in federal office. And that could, of course, include Donald Trump. So there's some question as to how much of a role that courts or judicial review ought to play with regard to Section 3 disability. But Congress has done this in the past. It has passed legislation to disable people from serving, right? Okay, so those are, I think, some of the major legal issues that have arisen from the events at the Capitol on January 6th. I would just simply conclude my portion of this by saying the following. Democracy is fragile. We often forget that in America because we have had such a strong country for so long. We often forget about the fragility of democracies historically. This was not right. Can everybody hear me again? Sorry. Okay, great. This was not lost on the framers of the Constitution. They understood, they knew about, they studied the failures of the ancient democracies, the ancient republics, and they talked extensively about this in the founding era documents. So keeping American democracy strong and resilient requires our adherence, I think, to a number of formal arrangements and institutional structures that limit the government, but that also control those who are governed. This means that the branches of the government have to be able to defend themselves. I have said this before, and I will say it to this group. The incident at the Capitol on January 6th was at its core an attack on the Congress, an attack on the constitutional functions of the Congress. And the government and the Congress in particular need a way of protecting themselves and in ensuring accountability for the efforts to disrupt the constitutional processes that were occurring on that day. There are a number of those, but among them are impeachment and criminal prosecution. All right, so I'll turn things over now to Professor Exum, and she can take a few moments, and then after she finishes, we'll answer some questions. Thank you.
Great, thank you. Thank you for those remarks, and thank you to all of you for being here. All 203 of you at this point. Because of fast-moving events as of late, we put the program together rather quickly. So I'm just really happy that so many of you were able to make time for this really important discussion. And I do also want to thank the amazing team that we have here at Detroit Mercy Law, who just at the drop of the hat put this together and got the word out. So many thanks to Grace Hinning and Sunny Kirschenheiter and April Ellison, and of course always for the continued support of Dean Crocker in giving us the space to do these sorts of things. So thank you all. And I also just have to say, I really love that we do this by Zoom like this so that, we get to see each other's faces. I think it's really great to get to see our Detroit Mercy community this way. So the legal issues that I'm going to focus on in my remarks are about the contours of the protected right to protest, the criminal consequences for acting outside of those bounds, including charges on the table and also criminal sentencing. But I thought it important for us to also think about how these legal issues fit into sort of the bigger context of the present day. Anybody who's had a class with me or if you've heard me speak before, you know that I always think that context and history are important. It's important to situate ourselves in our bigger story. And so, there's so many things that can be said about what's happening right now in our country, the violence and disorder, as we're calling it, at the nation's capital that we've recently seen. They raise the pressing issues of the moment, but they fit into really what I'll call the identity crisis that this country has really had since its beginning. This question that we've always faced, which is who are we at our core, and who are we trying to be? So this fledgling democracy, what are our guiding principles, our ideals? These have always been the imperative questions from really the beginning of our nation's history. And we've re-examined and re-raised them at every key moment in our history. So you can think of the Civil War and the end of slavery, Reconstruction, Jim Crow, Civil Rights era. These were all times where we had to, have these renewed conversations about who are we, who do we want to be? And so in so many ways, then this moment really is like all of our other moments. It's a time for us to examine ourselves, to be reflective, to understand more. It gives us an opportunity to have an honest conversation about who we are as a country, who we've been and where we want to go. So the word unprecedented, this is the buzzword. It was the buzzword of 2020, certainly, and for good reason, of course. And so far, 2021 is right on course to keep that word going in our vocabulary. So as of yesterday, of course, we have the first president in history to be impeached twice. His impeachment, as you know, was based on another unprecedented event, right? That we've had a violent mob to break into the Capitol, to fly the Confederate flag, even for what I understand is the first time in history that the Confederate battle flag has been flown in the Capitol as an act of insurrection, as we're understanding the mob to have been. And I think it's important also to say that it's the Confederate battle flag as a reminder again about context and history of what it was then and what it remains. A banner for the Confederacy, which stood as a military enemy, right, of our Union, and it stood for continuing systems of racial oppression, white supremacy, upholding ideals of racial hierarchy. All of that has never gone into our nation's capital. And I heard one historian say that talk about how there was an attempt to do this back in 1864 during the Battle of Fort Stevens, but that Union soldiers fought the Confederate soldiers back. And so the flag was never flown. It never entered the Capitol in that way. And so I heard this historian say the Confederate flag made it deeper into Washington, D.C. on January 6, 2021 than it did during the Civil War. So that's why I say this is a time for us to stop and reflect and say, who are we? Right? Who are we as a country and where are we trying to go? So as I turn to the legal issues and the consequences raised by last week's insurgents, I thought it was important to keep this bigger context in mind for the reasons that really we just heard, that the Constitution is not a self-enforcing document. Right. Courts can interpret it, of course, and we've already seen the courts called upon to sort of act in this role in, talking about the legitimacy of the 2020 election. As was just explained, I'm sure in the months to come, we'll have courts sort of spring into action to have to examine issues about pardon power and all of that. Right. And so our courts can interpret the Constitution and constitutional principles. But our Constitution really depends on our buy-in. That's where it gets its strength. So when we think about the fragility of our democracy, it's fragile because if we don't all sort of buy in, then it falls apart. But that's also where we draw our strength, right? From all of us. So those of us who belong to marginalized or historically oppressed groups, we all know how important it is to be able to rely on the rule of law, to turn to courts for our own protection, right? And so historically, we haven't always gotten that fair and just protection, of course, but at least the Constitution gives us a basis for a legal fight for it. But as I said, it only works if we all collectively agree to have some respect for the rule of law. And that's why I thought it was important to speak to you all today about the legal issues, but I didn't think that we could talk about them without having that bigger context in our minds. So over the next weeks and months, as investigations continue into what happened at the Capitol, we'll learn more about who was involved in the insurrection and to what extent. We'll learn about how much of that involvement, if any, can be attributed to members of Congress, any members of the Capitol Police or other government officials. As was said already, we'll need much more evidence and facts surrounding those claims. But as the investigation unfolds, I thought it would be useful to understand what the Constitution permits and what crosses over into actions that are not constitutionally protected. So one constitutional promise that's relevant at the moment, of course, is the avenue that the Constitution gives us for political and social disagreement and dissent. So I'll talk about the right to protest as that first legal issue that I'll touch on. And that way we can, properly distinguish the events at the Capitol from what's protected activity. So among other rights, the First Amendment of the US Constitution gives people the right to peaceably assemble and to petition the government for a redress of grievances. Now, the right to assemble has been a really crucial legal and cultural protection for dissenting groups throughout our country's history. So we can think of abolitionists, suffragists, right? Religious organizations, labor activists, civil rights groups have all invoked the right to protest and assemble against prevailing norms. So as we saw, we saw this summer, in the months that followed, by those protesting the overuse of police violence against Black Americans, other forms of systemic racial injustice. But when it comes to the right to protest, it's not absolute. So the government can impose restrictions on time, place, and manner of peaceful assembly, provided that there are certain constitutional safeguards that are met. So time, place, and manner restrictions are permissible so long as they are justified without any reference to the content of the regulated speech. So you can't have regulation based on stifling certain content or subject matter. Any regulations have to be narrowly tailored to serve a significant governmental interest, so they can't be overbroad regulations. And they have to leave open ample channels, alternative channels for communicating the information that the group wants to communicate. So such time, place, and manner restrictions can take the form of, say, requirements to obtain a permit to assemble. That's permissible. The government can make special regulations that impose additional requirements for assemblies, say taking place near public events, major public events. So when we think about what really we've come to understand to be pre-planned assembly at the Capitol, there were many ways for government officials to legally contain the scope and the breadth of that assembly. So we're now privy to, and this more and more of this will come out, of course, privy to, say, like FBI internal memos warning of a violent, quote unquote, war that was going to come to the Capitol just a day before the riots. So there will be many questions about, why there weren't more precautions taken. And they're all, rightful questions to ask as part of the current investigations. So thinking about the scope of the First Amendment right to assembly, it does mean that so long as protesters are either complying with permits, remaining in designated safe areas, they should be protected from any criminal charges or any undue use of force by police officers. However, the First Amendment does not provide the right to conduct assembly at which there is a clear and present danger of a riot, disorder, or interference with any sort of public safety measure. So for instance, you can't have protests that would impede traffic or pose any other immediate threat to public safety or order. And so it is permissible under the Constitution for the government, for law enforcement officials to contain protest in that way. And so of course, then the First Amendment doesn't cover or give rights or space to any assembly bent on any form of insurrection. So statutes that actually prohibit people from assembling while using force or violence to accomplish unlawful purposes, those are all permissible under the First Amendment. And this is where statutes like those criminalizing insurrection, of course, come into play. So we've thrown around the term insurrection. It's all over the news. Many of you now, you might have added it to your vocabulary, like unprecedented. Who knew we'd be saying that so much, right? But what does it really mean? Okay, so the definition of insurrection is a violent uprising against an authority or government. And so according to federal law, the Federal Criminal Code, for those of you who want to go and look it up, it's 18 USC section 2383. That's the crime of rebellion or insurrection. And so the statute says that it's a crime it's the crime of rebellion or insurrection for anyone to incite, set foot, assist, or engage in any rebellion or insurrection against the authority of the United States or the laws thereof, or to give aid or comfort to anyone engaging in that type of activity. So you might want to know what's the prescribed punishment for rebellion against the United States for insurrection. I'll ask you to take a moment if you don't already know. Mics are all muted, but take a moment to make a guess for yourself what you think that it is. All right, everybody have a number in your head? Okay, the statute says that such an offender shall be fined under this title for not more than 10 years. So fined or sentenced to imprisonment for not more than 10 years, or both, so you can be fined and also imprisoned, and shall be incapable of holding any office under the United States. So this might be a surprise to some of you, depends on how much you know about criminal sentencing and federal criminal sentencing. So especially, may come as a surprise if you're familiar with other federal offenses, like the mandatory minimums that apply to, say, drug offenses, Some of those are 10 years, 20 years, even mandatory life sentences for certain drug offenses. There are 10 and in some case 20-year mandatory minimums that apply for certain immigration offenses. These drug offenses, immigration offenses, the types of offenses that disproportionately affect Black and Brown people in our country. But, back to insurrection. Okay, so the next code, if we're thinking about what's on the table here, the next code section of the US Code, so 18 USC section 2384, covers seditious conspiracy. So that prohibits two or more persons in any state or territory or in any place subject to the jurisdiction of the United States from conspiring, that means agreeing with one another, to overthrow, put down, or to destroy by force the government of the United States, or to levy war against the government of the United States, or to oppose by force the authority of the government of the United States. So these are the types of charges that are on the table that prosecutors will be sorting through to figure out if there's enough evidence against any particular individual. Now, because the riots happened during the Electoral College certification process, the next part of that seditious conspiracy statute is also very relevant because it prohibits anyone from by using force to prevent, hinder, or delay the execution of any laws of the United States, or by force to seize, take, or possess any property of the United States contrary to the government's authority. So you can see how all of this is in play. Those convicted of seditious conspiracy can be fined under the title or imprisoned no more than 20 years or both. So keeping in mind, again, that these punishment provisions are not mandatory minimums. They're the upper level. So to say not more than 10, not more than 20, it means that a judge will have discretion in what sort of sentence to impose, but just can't go beyond 10 years or beyond 20 years, depending on the statute. The code also criminalizes advocating for the overthrow of the government. That could get a person up to 20 years in prison, plus the ineligibility to work for the US government for up to 5 years. So those are some of the relevant criminal charges on the table. Of course, a Capitol officer was killed during the riots and others died as well. So there will doubtlessly be homicide charges that are thought through. It's already been brought up about conspiracy, how that loops in anybody who's part of an agreement for all the crimes of anyone else. Felony murder is another criminal law mechanism that has been floated. This allows for someone who's committed a felony to be charged as a murderer, right? So charged as though they are the murderer if during their felony, their dangerous felony, there's enough of a proximate cause to a death that occurred during the commission of that felony. And then there are, I'll end by saying there are a host of other more minor offenses, or I'll say lesser, I don't want to call them minor, but lesser as far as punishment goes. So traveling interstate to incite a riot, that's up to 5 years imprisonment. Obstructing law enforcement, and these are charges, by the way, that have already been brought against some of the folks involved in the Capitol riots and insurrection. So obstructing law enforcement, that's up to 5 years. Knowingly entering or remaining in a restricted building without lawful authority. If you do that with a firearm, then no more than 10 years imprisonment. If there's no firearm, then not more than a year imprisonment. And then there's also a whole host of disorderly conduct charges, and those are all petty misdemeanors. So there are many legal avenues using the criminal justice system to address what happened at the Capitol, and we'll see that we're seeing that tool employed already. We'll continue to see it. We'll learn more about the evidence and the facts that are gathered. But I want to end my remarks where I started, which is remembering again both the fragility and the strength of our democracy and our Constitution. So criminal liability and punishment for the insurgents should be pursued, of course, right? But it should be pursued because there should be consequences for attempting to subvert our rule of law and to subvert and undermine the protections that rule of law should afford to all of us, right? But with the same energy that we use to swiftly and forcefully condemn violence that's meant to undermine our democratic agreement, that threaten the fragility, the fragile nature of our government, that same energy should be used to protect the space for protest and petitioning the government for redress of grievances that should be free from force, free from pushback, by law enforcement and other forms of social condemnation, because that's where our democracy draws its strength. So when we think about upholding the rule of law, it has to go both ways, condemning those who forcefully seek to overthrow our government structure, protecting and standing up for those challenging the shortcomings of our democracy within the space that the Constitution provides. So America is still in the process of self-discovery, right? And as we wrestle with all of the legal issues that are currently on the table, I hope that we seize this moment to work on moving closer and closer to embracing our constitutional ideals and who we say that we are, right? And who we'd like to become. So I'll stop there because I'm sure there are lots of questions and a great discussion still to be had. So again, just thank you all for being here.
Wonderful. Thank you, Professor Exum. Okay, so we'll be happy to answer some questions if folks have them. I know there have been a few in your minds probably already. Here's one that sort of came through the chat indirectly, but it was directed to me as a question from the chat. So one of the questions is, could the president, President Trump, resign and then have Vice President Pence pardon him? Yes, of course, that is a possibility. I don't know how likely that is at this point, but I have heard some commentators suggest that might actually be a preferred route for the president. And it's based on the following theory, as I understand it. Now, I don't think it's going to happen personally, but here's the theory. The one thing that the president might fear more than anything else, more than impeachment, more than, disqualification, the one thing he might fear more than anything else is criminal prosecution and imprisonment. Well, the only way to avoid that, really, to guarantee avoidance of it, would be to have a valid and effective pardon, right? So because of the constitutional questions surrounding a potential self-pardon, right, the only way maybe to guarantee a valid and effective pardon would be to resign and have Vice President Pence grant the pardon. That's fraught with all kinds of risk, right? You might resign and then Pence doesn't do it, right? And so that, how bad do you look then, right? So there's also the risk of sort of receiving the pardon and it being a sort of implicit admission that you have committed a crime, right? The pardon power can only be used for offenses against the United States. And we know that it doesn't apply in impeachment. And we know that it doesn't apply with regard to state offenses. But we know that it applies to offenses against the United States. So arguably, based on the constitutional text, you can only receive a pardon if you have committed an offense against the United States, right? So there's a lot of risk here. There's a lot of political calculation that would have to be made. But one argument might be that the easiest way to ensure no potential prosecution and imprisonment would be something like that kind of arrangement. Professor Exum, you're welcome to jump in if you have anything else to.
Yeah, nothing to add to that one. I agree with everything that you said.
Okay. All right. Let's see what else we have here. Okay, so a number of people are messaging me privately, which is fine. So I will I'll take these just sort of in order that I'm seeing them. Oh, can you elaborate on why there's a need for a grand jury to prosecute the rioters? That's required by the Constitution. The Fifth Amendment requires that in all federal prosecutions, at least, you have to have a grand jury before you can charge someone with a felony. Now, we often don't use the grand jury for misdemeanor offenses, right? But for what the Constitution calls capital or otherwise infamous crimes, you have to have a federal grand jury indictment. Now, that's not true in all the states, right? Because this is one of the very few provisions of the Constitution that has not been incorporated against the states through the 14th Amendment, is the indictment clause of the Fifth Amendment. So in a state prosecution, depending on what state it is, you might not have to use a grand jury, but in federal court for a federal crime, you have to have a grand jury indictment.
And I'll just add to that, in addition, of course, to it being a requirement, part of the reason for it is to give some legitimacy to prosecution. So this would be, a group of lay people who come together and see the evidence that's presented by the prosecutors. And it's sort of like the prosecutors asking the people for permission, saying, do I have enough? Do you agree that there's enough here to go forward in a trial against these individuals? And so I think it's hugely important in this kind of context where you can understand how legitimizing the process is really important. So apart from it being, it's required, it has to be done. But I appreciate the question because I think it's important to understand that this is where all of us come in, right? So those, folks who are pulled in to be grand jurors, this is where the everyday people come in to take a look at things and say like, oh, okay, yes, this needs to go forward as charges against these individuals.
Right. Okay, another question. Can the states still prosecute regardless of the pardon? Well, the pardon is only for federal offenses, right? So a presidential pardon is not valid as to state offenses. So yes, even if he received a pardon or anyone received a pardon for a federal offense under the pardon clause, that would not affect a state prosecution. So, and we know that many of the states are very much aware of this. So there are ongoing state investigations right now, including most notably the one in New York, arising from the president's business activities. So yeah, the states could still prosecute.
And one additional point there, it's not really on that question, but I also received a private question, which is related to the difference between state and federal issues. So it asks, do states have conspiracy laws or is that only federal? And so, in the same way, states also have conspiracy laws on their books, but it reminds me to point out that all of this happened in the District of Columbia, which also has its own criminal code. And so while there are federal charges, there are also charges that can be brought by the District of Columbia. And one key difference is that, say, for something like inciting a riot, which under the federal authority requires an interstate angle. So it was, traveling interstate to incite a riot. Under the DC code, it doesn't have to have that, as constitutional law students know, that jurisdictional hook. It doesn't have to be about crossing the state, any state lines. And so it's just a, sort of a different avenue for also charging some of the individuals involved.
Thank you. Can you refuse a pardon? Good question. So I don't know. I'm not aware of anybody attempting to refuse a pardon. And the first thing that strikes me is, why would you, right? But I guess the idea is, right, if receiving a pardon requires the implication that you have committed a criminal offense, that would be, in my mind, like the reason for refusing a pardon. Professor Exum?
No, same thing. I don't really know. I don't know the answer to that. I don't know what, if a pardon is issued, does it automatically stick or does somebody have to receive it? I'm not sure. But I would say, I can only imagine somebody pushing back against receiving a pardon because of those implications. And that might very well happen in this kind of context where to someone, their mission might matter, right? And so if they were bent on government overthrow, they perhaps don't want to receive a pardon that would suggest that anything was wrong with what they did. I could imagine it. I mean, again, we're in 2020 part 2, so who knows what could happen, right? But I don't really know the legal answer.
Right. It's an interesting question. I confess I hadn't thought about that much, but I think we have sort of put our finger on what would be the reason why you would do that. If the president were to resign and be pardoned, does this have any impact on the prosecution of others in a conspiracy or in the conspiracy? Well, okay, so I'm not sure that it would. And the reason for that is, the pardon would be specific to that individual. And the pardon would not have the effect of saying that a crime wasn't committed, right? I mean, this goes back to the old notion of what is the legal effect of a pardon? Is it to say that you didn't commit the crime? Or is it to say that you did commit the crime? That's why you get the pardon, right? Because you can't get a pardon if you didn't commit a crime. So I don't think that it would necessarily have any legal consequences for anybody else in a conspiracy, Professor Exum, do you have a different view of that?
No, I with you on that one. And I'm thinking, because on the last question, so I got caught up again on this last question about pardons, and so I went down a little bit of a rabbit hole. This is the downside to having technology in your hand. But Susan B. Anthony, right? The Susan B. Anthony Museum rejected a pardon that was issued recently by President Trump. So there's something there that there is maybe something. I don't know, how it would play out now, or what that means, but we do have some precedent for that. So I went down a rabbit hole during that question. But yeah, no, I agree with what you're saying about the possible conspiracies.
Yeah. Do you have any questions on your end that I have a few on my end. I didn't know if you had a few on your end that you wanted to jump in with. I don't want to dominate the question answering.
There's a question about if the president resigns, can he never run again? This actually is where the impeachment and possible conviction plays in and makes a difference, because a president can run again for office, but if there's an impeachment followed by a conviction, a part of the conviction could prohibit a president from running again. Right, that could be part of the sanction, so that's possible. And then, of course, these other possible crimes that we've already talked about. Some of them carry as their punishment ineligibility for federal office, so that could be a possibility. But just the resignation itself would not bar the president from running again.
Yeah, and I just want to say something about that too. The statutory disqualifiers, right? These statutory provisions that as a part of the punishment disqualify someone from holding office. I question whether that would be constitutional as to the president. And the reason for that is the qualifications for being president are established by the Constitution. So arguably Congress cannot alter by ordinary legislation the constitutional qualifications for being president. This is why I think Section 3 of the 14th Amendment is important. Because one argument might be that those statutory disqualifiers function as an application or enforcement of Section 3 of the 14th Amendment if it is for rebellion or insurrection, right? So that's possible. I'm not crazy about that argument just because I think probably Congress would have to enact specific legislation as to the individual under Section 3 of the 14th Amendment. I realize that whole process sounds a lot like a bill of attainder. Honestly, it is a bill of attainder, but it would be permissible because it is constitutionally recognized. It's kind of a pragmatic constitutional exception to the bill of attainder prohibition. But I would think that would probably have to be the process that Congress would use. So these statutory disabilities, at least as to the president, not as to other offices whose qualifications are not set by the Constitution, but as to the president, these statutory disabilities are probably unconstitutional in my view.
I did have another question that came to me. Someone says that they read an article on about Black Capitol Police officers, that they had been warning about racist Capitol Police officers for years, but were ignored, wondering how does this play into what we saw on January 6th? Also, there are more planned attacks on the US Capitol, as well as state capitals across the nation. How do we prepare or combat this? And so I'll take that question to to have two parts to it. One is about questions about what was known ahead of time, right? Ahead of the Capitol riots. And this is where I think we're going to learn a ton more. I mean, we already are, right? A ton more about what information was already out there, who was already saying, there's going to be danger more than just your regular protests, right? That might have, a little bit of violence here and there at the fringes, but that this is a planned attack that is going to be violent and that has, that had planned even more violence and harm than what actually, resulted, right? So we're going to get more and more information about how much was already known. And this is where we'll see, more about what, if there were, and to what extent any government officials were involved or lent any sort of hand or assistance to the attempted insurrection. On the other side of this question is about, well, given that we know there was some information, right, a warning about what was going to happen, what do we know about what's going to happen, prior to the, what do we already know about what might happen on the day of the inauguration? And so I've been, like everyone else, tuned into the news, trying to figure out what are the law enforcement preparations. We've seen all the pictures of the National Guard, sleeping in the Capitol. I heard numbers today saying that that Washington D.C. right now, it's always been heavily fortified, by the way, and we just don't always see it in our faces. But that the Capitol is more protected now than it ever has been, and has more National Guard presence than many other countries combined at this point. And so, so there's a real focus right now on the Capitol, and I think that there's more attention being paid to any sort of, tips and insights about coming violence. I also heard, this is a former FBI official and a few other national security officials talking about how to protect state capitals, and that they're also being, having security beefed up, and there's real eye on state capitals as well. What's difficult though is with the National Guard, they're not a body that is sort of sent out very quickly. And so they can't be used to, respond to 50 states all at once. And so there is some concern about that. I'm not, obviously don't know what the inside plans are, but it's on the minds of those who are tasked with keeping all these places secure. And also the last thing I'll add is that I've also been hearing a lot in the news and reading about a big concern about those who are going to be sort of the, like, I'll go it on my own. So they haven't been involved in the big groups and talking on social media and, posting and making plans all together, but they're sort of going to be the lone, insurgents. That those folks in many ways are very disturbing, because it's hard to track and to keep them. So, I'm just hoping that folks stay safe and keep that in mind. But this is a real concern.
Agreed. Thanks for that. All right, so here's an interesting question that implicates some of the fallout from what we've seen from last week. Any First Amendment issues with regard to the social media bans? As many of you probably know, the president has now been banned from Twitter and other social media platforms. Those platforms have taken action against others as well. So again, this is another one of those things where there's a easy short answer and then a more complicated longer answer. I'll start with the easy short answer, and that is no. These social media companies are private entities. They're not state actors or government actors. The First Amendment only protects you against government restriction of your speech, not from private restriction of your speech. So as long as we view these social media platforms as private, not government or state actors, they can ban as much speech as they want, right? Now, there's a separate question as to whether that's a good idea, right? I mean, so set aside the First Amendment problem, which I think is resolved through the state action doctrine. The bigger question here is, do the social media companies exercise too much power in this regard? Should their power with regard to how they moderate content and ban or accept users be reined in somehow? There's a pretty robust debate about that right now, and I think that's a worthy debate to have. One of our former colleagues here at Detroit Mercy, Professor Kyle Langvard, is an expert in this area of social media content regulation. He's done some excellent scholarship on this. I urge you to read it if you're interested in this issue. But yeah, I would say First Amendment issue, probably not, but larger issues about free speech beyond just the First Amendment context, yeah, I think there's a very interesting debate to be had there about the power of these social media companies with regard to how they moderate content.
I don't have anything to add there, but I did want to say, I know we're getting close to the end of our time, that I'm now getting lots of questions that I obviously can't answer them all, but I think it's important for you all to know a common thread that I'm seeing in the questions that are coming directly to me. There's a lot of anxiety and fear and concern in the questions that I'm getting that are relating to concerns about a rise in white supremacist beliefs, about infiltration of white supremacy into our military or police, about what folks are saying are unfair comparisons between the terrorist attack on the Capitol to Black Lives Matter protest, and I'm concerned about specifically the state of Michigan. What I want to say about that, because I can't answer it all in, however many minutes, and I don't know that I have answers for it all anyway, but I think it's important, we're talking about an attempted insurrection, right? Overthrow of government, challenge to our democracy. And that means something, right? It's potentially devastating. It is something that exposes how fragile our democracy is. But I think that it is hugely important to understand the sort of added fear and anxiety and concern that people of color in this country are also feeling when these things happen, right? So this is not just, because you have to think about, why did they want to overthrow the government? Why were they attacking Congress? What was their underlying goal? And that is giving rise to a lot of rightful, justified fear, anxiety amongst people who look like me, who are, concerned about basic things like going outside, right? During a time where this is what you're seeing in your face all the time. So my apologies to everyone who sent me the questions. I can't answer them all, but I at least wanted to honor your concerns and your fears and legitimize them in this space.
Thanks. Yeah. No, I agree with not only everything that she said, but also with the idea that there are so many questions that there's no way that we can possibly answer them in the remaining time. And I apologize for that. I mean, these are, I haven't read all of them yet because there are just too many to read at once. But these are all really good questions, and I appreciate them. I appreciate how much attention that everyone is paying to these issues. There's a lot of really interesting legal questions that have arisen during the last 4 years, right? I don't want to discount prior presidencies, but I think it's fair to say that for those of us who do criminal and constitutional law for a living, the Trump presidency has given us a lot to talk about and write about, and that's been valuable. So, it's unfortunate sometimes the contexts in which some of these issues arise, but nevertheless, I think it's important for those of us in the legal profession to grapple with these issues, regardless of party affiliation or whether you agree with Trump or disagree with Trump or whatever. Regardless of all of that, as lawyers, I think we have an obligation to grapple with these questions objectively, to really wrestle with the legal and constitutional implications of a lot of these actions. So this is a valuable conversation for us to have, and I really appreciate all these great questions. But as I said, unfortunately, there are just way too many questions for us to be able to answer in any remaining time. We're after 2:00 now, so I know a lot of people have classes to get to, or other meetings to get to, or other other obligations. I appreciate that. Professor Exum, did you want to say anything additional or answer any more questions?
Thank everyone for coming, and to echo that these are important issues, and the more you can educate yourselves on facts, on what the law is, on having discussions where you're actually understanding and helping others to understand these issues, I think is hugely important, and I'm really glad that that Detroit Mercy Law is getting the opportunity to help that along.
Yeah, I totally agree. And thanks not only to everybody who joined and participated today, but thanks in particular to those who helped to make this possible, the staff and administrators at the law school who put this all together. April, Grace, Sunny, thank you all so much for your help. So let's do this. I tell you what, again, a lot of good questions here. I'm happy to answer questions for folks. If you want to submit questions to me by email, send me an email. I'd be happy to answer your questions as I can. there's a lot of good stuff here that I'd be happy to talk with folks about. So just for folks out there, you know, if you ever want to talk to me about this, and I'm sure I speak for Professor Exum when I
Yep,
say this as
same
well.
here.
Yeah, please feel free to reach out to us. I, this is what I do for a living, right? I mean, this is, you know, we live and breathe this stuff, and so so I'm happy to continue the conversation. But given the hour, it's probably good if we stop today now for today. And I just want to say thanks again to everyone. All right. So.